There was an article written in The Advocate, Secretary of State to withhold voter lists from Lafayette Council candidates until August 1st. Yesterday, we had Kyle Owens, Secretary of State, on the air, and he talked about this, and I think he made a lot of good points. I got a gentleman here that wanted to call in. Mike called me this morning, said he'd be calling in. He's an attorney. Gary McGoffin, I hope I'm saying that right. Gary, how you doing?
Good morning, sir. Yes, that's the right way to say it.
All right. Well, I can mess up Gary, so I knew I'd mess up the last part of it. But anyway, Mike called. Mike said you wanted to call in, and you must have heard something you didn't like or wanted to respond to, which is fine with me. I like to have all sides. So, what is just state your situation, who you representing first of all, so we can kind of get that clear, and then we'll talk a little bit about what you heard yesterday that you may agree or disagree with.
Sure. I represent, along with two other attorneys, we represent 6 citizens of Precinct 74, which is the most affected precinct with regard to the clerical errors that were made in the textual descriptions in the charter.
Okay. Now,
so I participated in the trial on May 8th, and I participated in the hearing on April 3rd prior to that.
Okay, but you must have had some beef or something that Antoine said yesterday to Secretary of State. What was that specifically?
Well, there were several.
All right.
Let's start with the fact that Mr. Ardoin did not attend either of the hearings, so he's not speaking from firsthand knowledge of anything that he said yesterday. He made several statements, for instance, starting with the fact that there were statewide implications to what's going on here, that it could affect up to 60 other municipalities who are home rule charter
he did say that.
cities, and that it would implicate the state election code. If he had been in court, he would have heard his attorney state to the judge, Judge Trahan, that our home rule charter is unique in the state of Louisiana and that we are the only one that has included precinct boundaries in the textual description in the home rule charter. No other community that they were aware of had done that, and so they found that we were different. Because of that, the judge's determination as to the clerical errors and what we should do about it has no implication to the other home rule charter communities in this state, nor does it implicate the election code.
Mm-hmm. Well, go ahead. What was the other one that you made? You said it was a couple of 3. Go ahead.
Oh, yeah. If Mr. Ardoin had been at the trial, he would have heard Mike Hefner testify as to the process that was gone through to define the districts and to put this up for the voter approval on December the 8th. He would have heard that a demographer like Mr. Hefner starts with maps rather than textual descriptions, because everybody has to see where this is going to fit, and he came up with a preliminary proposal for both the parish council districts and the city districts. They went through several iterations, and the final 2 iterations that were relied upon by our council in sending this to the voters was version number 2 for the parish districts and version number 2D for the city districts. And those clearly set out, and their attorneys were there, and they saw them, and it's in the evidence in the record, where the boundaries for each of the districts and each of the precincts are. Mr. Ardoin would have also heard, if he had been there, Mr. Hefner describe how the error in the textual descriptions occurred, that there was an agreement as to what the boundaries should be pursuant to the maps, that he received a call while he was driving one day requesting the textual description of those districts and the precinct references, and that he pulled over on the side of the road, fired up his laptop, and sent a file which he thought was the correct file for the correct descriptions, but unfortunately it was a prior iteration of the discussion. So that's where the confusion came in on the text. The bottom line is everybody understood where the boundaries were. What we have is, and from my perspective, and particularly in representing my clients, we have a form over substance problem going on here. Everyone knew what the maps were. The vote came in, agreed that we were going to split the 2 council format to the one we have now. But when the language was plugged into the ordinance, it was incorrect. So at the trial, Judge Trahan, who I have to say is one of our best judges, he's from Crowley, he's not running for re-election, he had no dog in the hunt. He listened to it and he found several things. One was that there was nothing nefarious occurring, that this was an innocent error. He found that the council intended districts to conform to the maps that were put into the evidence, that the textual errors were purely clerical, and that the reapportionment ordinance, which was to correct all of this in March of this year, was presumed constitutional, and most importantly that the plaintiffs, which included the citizen plaintiff and also the Secretary of State, had failed in their burden of proving that there was either a constitutional impairment or anything contrary to our home rule charter.
Okay, now let's back up too, though. It sounds like Antoine's getting kind of yanked into this too. I know the Attorney General got involved in it a little bit by making an opinion on it. But yesterday on the program, he did mention by law he can only release those district stuff that y'all been asking for, so they can know who they can go call on, who can go visit, what area they're running in. He said that he can't release it. He quoted a law or something that said along the lines of 5 days before qualifying. And we're not even close to 5 days before qualifying. How do you justify that? But number two, this is not his fault. This was a screw up with the parish president and the council. And this whole thing has gotten blown up. And I'll be honest with you, if you walk out here in the public, people are livid about this, that they don't know what's going on. Now, we do have a court case. You just mentioned it. Nothing's going to be done till right before, quote, qualifying. So how does all that justify that Mr. Antoine said all this stuff that was wrong? That's what I want you to explain to me so I can have a better understanding. And I'm going to tell you what, the people here, they're livid about all the stuff that's going on because they feel like, and this is why probably Robideau's not running, and the council's all screwed up because of what they did back then before the election. People felt like they voted. They felt like they had a chance. They voted, and boom, look what happened. So just two or three things. How do you justify what he says that he can't release anything? Number two, I feel like he's getting dragged into this on something he had nothing to do with.
All right, well, you've got several questions
there.
Let's start with the fact that he cannot release anything until August the 1st.
Okay.
August the 1st is a deadline by which he must have the voter rolls prepared so that they're accessible to candidates. And that's to certify the final voter rolls for whatever elections are coming up. But that's not a prohibition to him releasing the data that he has now. He has had access to the correct information at least since the trial on May the 8th, and he's chosen not to rely upon that information that was put into the record.
But, Gary, can I stop you a second? Gary McGoffin, of course, my special guest. Gary, the only reason I'm stopping you is that when you look at the process, we have a court case that's not settled yet. So if you look at Mr. Antoine, and I'm playing a little devil's advocate with you, if you look at what he's saying he's doing, there's a court case out there, and the court case is being dragged on till July 28th or 29th or something like that. So, man, that kind of puts a guy in a bind. If I'm sitting in his position, I'm not wanting to make a decision, then the court case comes in totally different. Maybe he anticipates, maybe you anticipate. All of a sudden, you got a new problem. Is he wrong by being a little bit prudent there?
Well, I don't think it is prudent, number one.
Why? Why don't you think it's prudent?
Well,
I'm just kind of curious.
Sure. Number one, he was not drug into this case. His attorneys filed an intervention and asked to be allowed to participate in the case. No one sued him. He sued to be a part of this process. And that's fair. That's okay. Appropriate. I don't have any quarrel with that. He is represented by the Attorney General. The Attorney General had already rendered an opinion contrary to that which was rendered by the LCG attorneys, saying that this was prohibited. But all the Attorney General did was look at the four corners of the piece of paper that the Home Rule Charter is typed on. It did not look at the process by which the districts were determined. The proposition was sent to the voters, and by the way, the proposition that was voted on does not include the precinct descriptions. It's a 200-word thing saying, do you want to split the councils, do you want to have the elections? So rather than looking at the true intent of the citizens of Lafayette under our Home Rule Charter, he looked at that document, that piece of paper. Now, I heard him say several times yesterday that his is not a political office. But when you look at the Attorney General opinion which was rendered, you see how it came about, and you see the timing on it, I have to think it is political. Now, was Mr. Ordway a part of that process? No, I can't say that. But I do have in my hands right here the emails that originated on March 15th, from a member of the Lafayette Republican Executive Committee to Senator Hensgens, sending him a draft of the Attorney General opinion, or the request for an Attorney General opinion that they wanted, with their rationale for why this was inappropriately done. So there was an exchange between Senator Hensgens back and forth and with the Attorney General's office during that time period between March 15th and March 25th when the official request went in. The Attorney General's office actually, and this was the attorney who tried the case for the Attorney General and the Secretary of State, on March 25th actually sent to Senator Hensgens, and I quote, "The attached draft of the opinion request that you would like to submit in regards to the charter amendment by the Lafayette Sierra Parish government should suffice as a formal request on the issue." So we have Mr. Ordway's attorney working with the political body to request an opinion.
But Gary, let me ask you a question. But he's kind of naturally brought into the process, but because we are talking about voting, he is in charge of the voting that goes on in the state of Louisiana. So he's naturally going to be brought into the process anytime you have lawsuits like this. Let me ask you one quick question. When you represent the people you represent, all y'all asking, and I'm just saying, y'all may be asking a lot more than I know. All y'all asking is for him to release this information so the guys can, ladies and gents, can go campaign. Is that really what your gist is?
No, I have nothing to do with that. My responsibility to my clients is to assure that they can vote in their precinct and they can vote in the elections that they voted last year to have.
But the precinct hadn't been totally determined, because aren't we waiting on a lawsuit in a court battle right now to get finished before all that can be done?
Here's how that works. The plaintiff, the citizen who filed suit, and the Secretary of State both requested at the May 8th hearing that the ordinance from March 26th, the corrective ordinance called the reapportionment ordinance, they asked that it be enjoined, and the practical effect of that would have been to stop us from having the elections which were scheduled in October. It would prevent our citizens from being able to qualify for office in the August 6th to the 8th period and to vote for those offices. It also, and this is the concern I have from my clients.
That was my next question. I want to know if you have a concern.
Sure. Precinct 74 is the most impacted precinct in the whole discussion. And the reason for that is in the textual error, there was reliance upon the Cooley Mean being a boundary for Precinct 74 instead of University Avenue. And between Cooley Mean and University Avenue are about 300 or so voters who, as of right now, because of the textual error,
they don't have a clue which
would be
way
left
they're
out.
Okay.
And they'd be in the twilight zone. They wouldn't get to vote. They wouldn't get to qualify.
The real quick, if you do me one more favor,
sure.
If it rules in your favor, what exactly will your clients get out of this? What happens? And if you lose, what happens? Give us the scenario, win or lose, what happens? Because I think people want to know exactly what will take place depending on what happens at the court battle.
Sure. Well, let's be very clear. My clients have already won. The court has already ruled. Judge Traha, who was the district court judge, rendered a ruling in open court on the day of the trial saying that the Secretary of State and the citizen plaintiff had failed in their burden of proving there was a constitutional problem or a problem being contrary to the charter, and he dismissed their claims and their request for injunction. My clients and the Lafayette Consolidated Government parties simply want the elections to go forward, as was voted on December 8th last year by the voters, and that the reapportionment ordinance, which has been used in the past, and which is sensible here because we have a true reapportionment of Lafayette Parish. Although it's not pursuant to census, when you take a 9-member council that is parish-wide and you divide it into 2 5-member councils, Each one of those councils is a total reapportionment of the parish. So it's appropriate
I get
what
it.
the council did.
Yeah, I get it. All right, sir. I got to take a break on this, Gary. I appreciate it, man.
Sure.
I really do.
I have one more thing. I'm really disappointed that the day after the trial, Jeff Landry called a couple of interviews over here and disparaged Judge Trahan, saying he had his mind made up, hadn't listened to the evidence. None of that was true. And it's unfortunate that Judge Trahan is not in a position to defend himself because he's a judge.
Mm-hmm.
But I want to make sure everybody knows that as well.
All right. Appreciate the call, man. Good luck.